All right. With that, we are way behind. My fault. We need to move forward with we're going to move things around a little bit to accommodate guest schedules. And so, first up is going to be the Practice of Law Board report with Chair Michael Cherry. And then following that, we will move up to the Board of Bar Examiners report from Chair Turcott, Chair Hellman, and WRSD Admissions Manager Gus Quinones. So is Michael Cherry on the line?
Yes, President Cicchetti, I am. And I believe Rex may have my slides. I'm not sure how he's going to put them up, but let me just start. Thank you, President Cicchetti, governors, members and staff of the Washington State Bar Association, and members of the public. I'm here today in my role as the current chair of the Washington Court's Practice of Law Board, which is one of the Supreme Court boards administered by the Washington State Bar Association. I thank you for giving the Practice of Law Board time on your agenda and for moving us forward today. Although I am presenting this information, before I begin, I would like to acknowledge that this presentation represents the combined work of a group of volunteers from the Practice of Law Board and the Access to Justice Board's Technology Committee. These volunteers have spent many hours reading the literature on this subject, as well as reaching out to and meeting with such people as John Lund, board chair of the Utah Office of Legal Services Innovation, Crispin Passmore, a consultant who has been a key proponent of legal reform in the United Kingdom. And we have worked with the staff of the bar, including the staff of the offices of General Counsel, Discipline, and Admission to Practice, and with our liaison to the Washington State Board of Governors, Governor Angevil. We've attended CLEs on the subject, including an excellent program at Gonzaga University, where our own Supreme Court Justice Stevens, as well as Utah Supreme Court Justice Hermanis, and Dean Andrew Pellman, Dean of the Suffolk Law School and Professor of Law, who has written extensively on legal reform, were part of an informative panel on legal reform and access to justice. Under Washington Court General Rule 25, the Practice of Law Board has three responsibilities. The first is to educate the public about competent legal assistance. And to fulfill this, the Practice of Law Board is working on a legal checkup program. Rex, you could go to the second slide. The program most people know the Practice of Law Board for is the third responsibility, reviewing and, when appropriate, referring unlawful practice of law complaints to the appropriate enforcement agency. I am here today regarding our second responsibility, to recommend to the Supreme Court new avenues for legal services. On the third slide, we're trying to illustrate that the Practice of Law Board has spent considerable time over the last several years working to understand the nature of the market for legal services in Washington State. This includes services provided by individual legal practitioners who have been authorized by the Supreme Court to practice law in Washington, our attorneys, licensed practice officers, and limited license legal technicians. As represented in the illustration, these people provide legal services through large law firms, medium-sized law firms, solo or small law firms, triple LT firms that form the base of the illustration, and through the legal aid agencies that are shown at the top of the illustration. This is a representative chart. This is not saying that every one of those squares represents only the law firms, but they represent the law firms that provide services. Not shown in the chart are the legal practitioners who provide services through courts, government agencies, and corporate counsel. But the Practice of Law Board has focused on a growing number of internet or online-based legal service providers, as shown in slide 4. At the time of this study in 2020, the Practice of Law Board identified over 50 unique online legal service providers. Some of these services target legal practitioners, and some target consumers. As shown by the overlap in the diagram, others target both segments of the market for legal services. Today, there are even more such services entering the marketplace. Slide 5 shows that these online legal service providers offer legal services across a wide spectrum of legal matters. They will help with divorces, contractual clauses that force arbitration, traffic infractions, and getting a visa. Some services offer referrals to legal practitioners. Others are pure do-it-yourself legal services where the consumer does the work through an online application and appears in court pro se. In many cases, a commissioner or judge will be unaware the documents the pro se individual is presenting came from an online legal service and not from a lawyer. These online legal services can show glowing reports from the press illustrating how consumers are using these services to address their legal needs. This is a multi-billion-dollar market today with even more venture capital flowing to these firms. And we're already seeing firms are merging to gain additional market power. On slide 6, looking at examining these online legal services, the Practice of Law Board has observed that these services may be addressing the access to justice gap. That is, they are getting people with a legal issue connected with a legal service which can help them with their issue. They appear to offer focused and timely advice in a manner that consumers, particularly young and busy consumers, want and can afford. However, they raise several questions. Who monitors the quality? Which regulations should apply to these services? And if a regulation does not apply to a service, why should it apply to a legal practitioner offering similar legal services in person? Should these services be licensed or admitted to practice law? On slide 7, we're showing you that the Practice of Law Board is not alone in asking these questions. This chart shows a variety of ideas for both closing the access to justice gap and introducing new and authorized legal services. Some states are looking to license new types of legal practitioners. Others are looking at changing regulations, such as changing rules about referrals, fee splitting, and of course, the long examined and debated changes to advertising rules. Like British Columbia, California, Florida, and Utah, the Practice of Law Board is looking into creating a legal regulatory sandbox, particularly to test online legal services and alternative business structures by empirical observation, measurement, and data collection to determine what level of regulation is required. A legal regulatory sandbox allows a non-traditional legal service, for example, an internet-based legal service, to offer legal services, including the practice of law, while the data about the effects of the service on the access to justice gap and consumer harm are evaluated in a low-risk data gathering environment. The next slide shows an infographic from Bloomberg Law that shows a similar picture of movement towards addressing the new market for legal services by ownership reform. Arizona and Utah are taking the most aggressive steps to address market conditions to close the access to justice gap. The Practice of Law Board strongly feels there's considerable risk in doing nothing about these online legal services. They will not go away. The market for legal services is too large. Investment in such services is growing. And perhaps most important, the network effect means there is a great danger of spontaneous deregulation, where the consumer's acceptance and use of the services makes it virtually impossible to remove them from the market or impose regulation. The network effect, if you're not aware of it, can be seen in the past for its role in defining the market for PC operating systems, web browsers, ride sharing, and short-term rentals of real property. Today, many online legal service providers are entering the Washington legal services market by following an assurance of discontinuance that was issued between the Washington State Attorney General and LegalZoom, as if this court-approved decision provides a safe harbor. Do the same things as required by LegalZoom, and you're good to offer legal services in Washington. At the Practice of Law Board meeting with the Supreme Court in February, the Practice of Law Board promised the Supreme Court that the Practice of Law Board would bring a proposal to address online legal services to the court. The Practice of Law Board will be proposing that Washington courts create a legal regulatory sandbox to allow the Supreme Court, the Practice of Law Board, and others, such as the Access to Justice Board and the Washington State Bar Association, to evaluate the provision of online legal services to ensure they're closing the access to justice gap and not harming consumers. The legal regulatory sandbox the Practice of Law Board will be proposing tries to allow legal practitioners and entrepreneurs to provide innovative and non-traditional legal services while the Practice of Law Board, and again, the other interested parties, build the regulatory relationships and frameworks and collect data so that data-driven decisions about whether such services are addressing access to justice and are not creating consumer harm can be made. It is not the goal for the legal regulatory sandbox to allow entities to provide online legal services to skirt regulation, perform the unlicensed practice of law, or to create additional bureaucracy. While all the details have not been finalized, the Practice of Law Board is looking to fund the legal regulatory sandbox using fees from the legal regulatory sandbox participants or from grants and not from current legal practitioners. Much of the Practice of Law Board's work in preparing this proposal for the Supreme Court has been on problems such as how does one measure whether a legal service closes the access to justice gap while minimizing potential harm to consumers. This is a model the Practice of Law Board is working on for analyzing the risk and benefits of an applicant applying for and operating in the legal regulatory sandbox. The horizontal or x-axis is the risk of harm to the consumer. The vertical or y-axis is how much of the service addresses the access to justice gap. Finally, the z-axis, which admittedly creates a 3D model, considers when the harm to consumers is most likely to arise, now or in the distant future. For example, those services that reduce the access to justice gap with little risk of harm, those falling in that green box that says approve, would likely be admitted to the legal regulatory sandbox for further study. Those services that do not positively affect the access to justice gap have a high risk of harm, and such harm might not be detectable for years. Those falling in the red box marked reject are not candidates for either the sandbox or, frankly, to provide legal services. The remainder of our work on the proposal focuses on the process for getting into, operating in, and exiting the legal regulatory sandbox. The Practice of Law Board has to address the application process for operating in the legal regulatory sandbox, management of the sandbox, interaction with the Supreme Court, and finally, how to fund this sandbox. So what are the next steps? The Practice of Law Board will be presenting our first draft proposal to an en-banc meeting of the Supreme Court in July, just barely meeting the Practice of Law Board's objective from our February meeting with the court. It's important to note I say draft because this will be an iterative process. There's still a lot the Practice of Law Board and others like Utah ahead of us have to learn about this new way of creating regulation. There are unknown unknowns, things that the Practice of Law Board does not know, it does not know. As these unknowns come to light, the Practice of Law Board will address them and incrementally improve the legal regulatory sandbox. The Practice of Law Board will continue to work with all the interested parties, such as the Board of Governors, to move this forward. The Practice of Law Board welcomes your input. Thanks for the opportunity to tell you what we're proposing to the court and to get your feedback. If there's time, President Cicchetti, I'd be happy to answer questions from the Board of Governors or the public.
Thank you, former Governor Cherry and Chair Cherry. I do see one governor with his hand up, so we'll recognize Governor Williams-Ruth. Any other governors that wish to ask Chair Cherry questions, please also raise your virtual hand. Governor Williams-Ruth.
Thank you, Mr. President. Chair Cherry, thank you for your time and dedication. And again, I appreciate the time you've spent on the phone talking to me about the work that you're doing. And as I was listening and as I've been reading about the regulatory sandbox, specifically the California model and what they're going through, it got me thinking about NCAA athletics and wondering if when with the proposal that'll come forward, if there's going to be some level of question regarding discipline that will be the equivalent of lack of institutional control. Because if you're not familiar with NCAA athletics, there are all sorts of rules and regulations that can be violated by an individual player, a coach, a whole team. But then it gets to a point where It's an entire lack of institutional control. And as we're going to be opening, I mean, this is one of the unknown unknowns that I think might be out there, is that as we create this new framework, what will be out there for any organization, company, structure, so that way it's not just going to be about one person, but it's about if and I'm not going to pick on any one company, so I'm not going to say name, but if a company that engages with multiple different attorneys to exercise services, but then they can be scot-free from any responsibility for what comes out of that practice. And all of the times I used to work in other firms, the firm was teaching me to ensure that I would not have the potential ethical violations or RPC violations as an individual attorney. And so I just wanted that, it's more of just a comment of, I'm hoping that whatever we come forward with, and as you present, that there's going to be a way that ties a responsibility, so that way we can't just have one, mega billionaire decide to create a product that then is unleashed on the people, and there's really no way to hold the higher level people accountable.
Thank you, Governor Williams. We're very concerned about monitoring the ongoing operations in the sandbox. And the current thinking is that on a 90-day basis, we would review data submitted by the entity practicing in the sandbox for review, and we would be constantly monitoring. Utah, for example, and I think we're going to follow the Utah model, any lawyer who commits a disciplinary infraction while in the sandbox is still subject to discipline of the bar. And my thinking about the entities when non-lawyers are involved and there's harm would be that we would use the appropriate agency, for example, the Attorney General's office, to look into matters of consumer harm, particularly fraud or inducement that was incorrect. We're going to have to monitor to prevent the kind of things that you are talking about. And I think even the Practice of Law Board, or whichever board is monitoring this, will also have to be subject to review to ensure that it isn't moving in the wrong direction.
Thank you, Chair Cherry. Governor Peterson.
Yeah, thank you, Mr. Cherry, and thank you for all the work you do. I will say up front, this really does concern me, at least in the area of corporate law or business law. I've seen the work of these online services, and frankly, it's borderline malpractice. And the fact that we would be somehow giving them a badge or something they can put on their website that they're approved by WISBA is of great concern to me. And that really goes back to, one of our chief duties is to protect the public, right? And I don't think bad legal service is something that promotes access to justice. Thank you.
Governor Pearson, one thing I might point out that I think that this might improve is that if you look at a situation like LegalZoom, they've been operating under this assurance document, but not really subject to ongoing review. And what we're trying to build into our model is the sort of review that might catch these bad systems. I'm not saying LegalZoom is a bad system, but if somebody is out there providing bad service, I'm hoping we're building the regulatory control that gives us a consistent look into it so that we can stop those things. It's not a carte blanche to do anything.
Thank you, Chair Cherry. Governor Pertzer.
Yes, thank you. Mr. Chair, I'm just curious. It seems to me like this is trying to regulate private enterprise, and I'm not sure how the bar can do that. And so I'm curious, is that this is to be a legislative process? Because I'm not sure what control the Supreme Court would have over a private business. And so I'm just not clear about how that works. So if you can explain that to me.
The way that it's working in other jurisdictions, to the best of my understanding, is that each entity operating in the sandbox is operating under a court order provided by the court, which outlines the boundaries of the legal services they provide. We're not, I believe, stepping into telling them how to run their business, how to make the day-to-day decisions about their business, how their entity is structured. Although I will say that a majority of what I'm seeing in Utah, the people operating in the Utah sandbox, the majority of them are law firms that are trying different business models. And so we're just trying to regulate the law side of the business, not the entity formation or how they run their entity.
Okay, thank you.
Governor Stevens.
So I guess my question actually for you, Mr. Cherry, but also for the executive director. I normally when we have a presentation, as that's going on, I look at the materials that have been submitted. And there are no materials, and we do not have, as far as I know, your PowerPoint. And so I'm asking one, I think we should always have that, and I don't know why we don't at this point. But I'd like that at least corrected and supplemented. So I would like at least your PowerPoint submitted and added to the record and provided to at least the governors as well as any of the public that attended this meeting, because it's great to have this conversation, but I like to review as we go along and not just try to recall everything I heard or saw, but only saw for a minute. So I'm not even going to get into the technical aspects of this, but I don't know what you're asking from the Board of Governors, but without something that I can review and really think about, that's a hard case for me.
Governor Stevens, I apologize. The fault is mine. I, as a former governor, should have been more aware of the deadline for materials. I'm working on this almost every day, and time just got away from me. So the blame for not having the materials in your book is solely on mine, and I apologize, and I will work hard to see it doesn't happen again. I'm not really asking for anything at this time other than to start to make you aware of what we're thinking of and what we're looking to do. I assure you, you will see the proposal and you will get a chance to comment it because I value the comment of the Board of Governors. But we're on a tight timeline due to the commitments we've made to the court. So expect to see things out of schedule a little bit, not necessarily for a BOG meeting, but I will make sure that the governors do get a draft of the materials with time to review.
And I just say, even with that time frame, I mean, while we don't like it, Governor Cherry, we have late materials and we even have late materials. So don't let the regular book stop you from going ahead and submitting so that perhaps Shelley and Tara can work their magic. So thanks. And I'm
point taken, Governor Stevens.
All right.
Governor Knight.
Thank you, President Cicchetti. Thank you, Mike, for your work on this issue. I have a question for you. I want to say first that I do share some of Governor Peterson's concerns about regulating entities in a way that essentially gives the WSBA's badge of approval to an entity where there's no lawyer connected. I want to follow up on one of your network effect analogies. You discussed ride sharing. I think you're referring to Uber and Lyft as it relates to the old-fashioned taxi industry. Is that right?
I think that's a good analogy, yes.
And so I understand why you make the analogy. I have some pause about that. And I think it's this. I don't think the rise of Uber or the problem with Uber is due to local government's failure to regulate Uber. I think it is with the taxi industry failure to emulate Uber. Uber is better than a regular taxi. and the old-fashioned industry didn't emulate it. There's some small components of online legal services that are better than traditional legal services. Many areas of law, preparing a will, preparing an LLC agreement, in some ways can be automated and be done for significantly less cost. I understand that, and lawyers, smart lawyers, should try and adopt those things. But why can't they be connected to a traditional law firm where a lawyer, an individual, is regulated, as opposed to an entity that can just poof, shut down, go away the next day? It seems to me that the best approach here is to, allow law firms to have services where people fill out, certain blanks in a form. A will is automatically generated. The lawyer individually reviews the will, meets with the client to discuss the will. A number of law firms do this very successfully, but it's always tied to an individual licensed attorney. And I just think it's important to keep that in mind and, look at our longstanding model of regulating individuals with an eye towards protecting the public. Thank you.
Thank you, Governor Knight. President-elect Tollefson.
Thanks very much. A couple of observations or maybe questions for you, Chair Cherry, former Governor Cherry. First thing is how are you gonna, and you might, I'll just ask the questions and you can observe. Was there any discussion amongst the members of the board about what to do about entities or individuals that are solely overseas, don't even have a U.S. presence? And the other question is, as you know, because you've been in the technology business for a long time and you follow technology, a lot of times it's very difficult for a regulatory authority to keep up with the market, keep up with the changes, and a lot of times fall behind. And we've seen this in industry after industry after industry, especially if they're connected to the internet. So how's the Practice of Law Board or any regulatory entity going to be able to keep up with these fast-moving changes?
It's going to be very hard for us, President-elect Tollefson, to know where some of these entities are practicing from, and it is quite likely that some will be U.S. based, some are Washington State based, some are based in other states, but some could be based in other countries. That's a reality of the internet. But whatever board, and I'm not saying that this is going, we don't know yet who is the right authority to be monitoring this. It may be the Practice of Law Board, it may be Washington State Bar Association, but it may be like Utah, where we have to create an entity, another board, if you will, to manage the sandbox and this new form of regulatory review and licensure. That board is going to have the resources to continually monitor for what you're talking about, new services entering and exiting the market. And it is going to have to keep an eye on that and grow to be able to handle that kind of volume.
Governor McBride.
Thank you, Mr. President. So, Michael, I want to thank you for being here. And I'm very supportive of your thinking through the regulatory function and how to get in front of this and how to fund it. If I recall correctly, it's 1933 when the practice of law was made a misdemeanor. And even back then, when there wasn't very many people in state and there wasn't very many attorneys, it was.
I'm sorry, Governor McBride. I think we may be having internet issues or connectivity issues.
Oh, can you not hear me?
Now we can hear you.
Now we can hear you. Yep. Thank you, sir.
Oh, should I start from the beginning or did you get most of it?
Start again.
Okay. So I just wanted to say I'm very supportive of what you're trying to do here. The criminal enforcement of unlawful practice of law has never been a very good model. And I think as we branch out into these other functions, we need to think through how we're going to regulate, because the criminal system won't be a good model for enforcement. It was 1933 that we made it a misdemeanor for the unlawful practice of law. The legislature bumped it up to a second time to Class C felony. It's just not a fit for our system. It never will be. And so this sandbox or this regulatory format, it reminds me of what we did with consumer protection. We created consumer protection units that didn't really rely on the criminal justice system. So I'm a supporter of where you're going, and I'll try to be more involved as you go forward on it. So thank you for being here.
Thank you. And we have a lot to learn, and, we're working with the other jurisdictions. And, one of the other things I'd just like to point out to the governors is that I've reached out to a number of people, to Dean Perlman, and to some of the other jurisdictions, and giving a great deal of thought to creating a common database for all of us to use, so that we're all measuring the same things. We're all measuring the same consumer complaints. We're all measuring the same data, so that we can all benefit from. So if Utah has more participants than we do, or we have more, that the common set of data that we all collect and share helps lead to better decisions as well.
Thank you, Chair Cherry. Governor Stevens, you still have your hand up, and Governor McBride, you still have your hand up. Do you have comments? No. Governor McBride? No. Governor Williams-Ruth.
I just wanted to tack on to what Chair Cherry was just saying about looking from the other jurisdictions. And I say this as a former member of the Character and Fitness Board, is that works great when you have an apples to apples comparison. But for us to, for us to look at the rules and regulations of Arizona as it relates to character and fitness, or Texas, and then Washington, it was not at all a direct correlation that was helpful in any way, shape, or form. So as someone who doesn't have the ability to join in on your board as much as I would love to, I would just say that borrowing information and not recreating the wheel, amazing, spectacular goal. Just make sure it's the wheel that we're creating, and that what we're looking at, because to take someone else's data means that we're having to drive by all of their assumptions and what they're doing. So I look forward to seeing where this goes.
Thanks for that. Thanks for that piece of information. It's very insightful and it helps. Thank you.
All right. I am not seeing any other hands, virtual or otherwise. Would you like to make any final remarks, Chair Cherry?
No, but I do just appreciate your consideration. And this is a hard problem, but I think if we all work together, and I'm working very hard to keep other boards, such as the Access to Justice Board and the Board of Governors, informed and aware of where we're moving. And I do respectfully want your feedback, comments, and concerns so we can try to address them. We're hoping to try something new. It may be a colossal failure, but I'm hoping it's something that we can make succeed and help us move forward. Thank you.
Thank you, Chair Cherry. All right. Hold on one second. We are evaluating our schedule here to see if we have presenters for the next item. Chief Justice Gonzalez, we noticed that you turned on your camera. Did you have anything to add to the last topic?
Just briefly to say thanks for the presentation today. So far, the presentation about this work was given to me and Justice Madsen and Justice Stevens. The rest of the justices haven't heard the presentation yet. I gave them all the link to today's meeting in case they wanted to get a preview. I'm not sure if anyone else of my colleagues is on the line today, but we're very interested in this work and, of course, the Boggs view of the work. It is a complicated topic that has a variety of positions. Some say the work is important because these services are happening anyway without our involvement, and we can either choose to be uninvolved or to be involved in some way. Of course, what that involvement looks like is a work in progress. So we're curious about the input. We're curious about the antitrust implications of being involved and what that would look like, and a whole list of other issues. But we'll be hearing another presentation, all 9 of us in Bonk, and we look forward to the ongoing dialogue. So far, no decisions have been made, except that I'm intrigued by the topic, as I know that many of us are. Thanks for the chance to say a few things, and I'll be signing off now.
Thank you, Chief Justice, and thank you for joining us this afternoon. We appreciate that.